Hello, everyone. My name is Nick Williams. I'm the Campaign and Policy Officer at Index on Censorship, so I'll be chairing today's session. You won't hear a lot from me because you're here to hear from this amazing panel. I just want to say, obviously, we're marking the five-year anniversary of the assassination of Daphne Caruana Galizia, so Malta's sort of premier investigative journalist who was killed in a car bomb 5 years ago on Sunday, so 16th of October. I've been working on Daphne's case in 3 different jobs, and it's been one of these cases that there's so much that it illuminates. It illuminates what we thought was a healthy media environment in Europe, but actually there's incredible dangers to journalists across Europe. We saw that assassination of Daphne, but also of Jan Kuciak and George de Vries in Netherlands and Yorgos Karavas in Greece. But we've also seen the use of SLAPPs, which are strategic lawsuits against public participation or strategic litigation against public participation. They're sort of interchangeable. People may use different ones on the panel, but they're meaning the same thing. I'm going to steal a quick definition for us today. I'm stealing it from the Coalition Against SLAPPs in Europe case. And SLAPP definition is abusive lawsuits filed by a private party with the purpose of silencing critical speech. There's a lot of discussions as to what definitions fit, what are the characteristics of a SLAPP, but I think for today's session, that gives us quite a neat encapsulating term. So what's going to happen, I'm just going to pass on to our panel. They will speak for a few minutes talking about their experiences of SLAPPs, and then we're going to have some questions and answers from me, and then I'll open it up to you. I would say if you can keep your questions till the end, but I'll make sure we can get to you. So without further ado, I'm going to pass on to Cora, so Corinne Vella. And Cora is the sister of Daphne Caruana Galizia, and she's the head of media relations at the Daphne Caruana Galizia Foundation, which formed after Daphne's murder to call for justice and has done exemplary work mapping and analysing the impact of SLAPPs, both in Malta but across Europe. So Corinne?
Thank you, Nick. Good evening, everybody, and thank you for being here tonight. I've been asked to sort of talk a little bit about Daphne's experience. I've been fortunate enough not to be slapped myself, but then I was not as vocal as Daphne was, and I did not work as a journalist as she did. I mean, the numbers are reasonably well known, but I'll just revise those for you. When Daphne was killed, she was facing 48 libel suits. 5 were criminal, which could have had her ending up in jail. And there were 43 civil suits. 1 was filed in the US, and that one was for $40 million. That's the one case Daphne didn't know about because we only discovered it after she was killed. But had she known about it, it could very well have defeated her because the scale of mounting a defense would have been impossible. The meaning of SLAPPs, I mean, that's something quite well known now, and that apparently is as a result of Daphne's murder, because her murder focused a lot of attention on her experience, and part of that experience was, facing down SLAPPs. We didn't actually know the meaning of the term. We didn't even know it existed until Daphne was killed. And that's because all the cases filed against her were actually grounded in the law, which gave the appearance of moral legitimacy to anybody who wasn't looking closely enough. Whereas to us, it is very clearly part of an orchestrated campaign to shut her up. The simple fact of having to mount a defense against multiple lawsuits, it drains your time, your energy, your money, and, it grinds you down. I mean, she was a fighter, but, if you're going to spend your time fighting lawsuits, you've got little time and money and space for anything else. In one notorious situation, a person who donates money to the governing party filed 19 cases against her. And when she questioned that, he said to her, I can do that because I've got a lot of money. So he wasn't even pretending to do it because he felt he should defend his reputation. He actually openly said he was doing it to punish her. And he kept suing her even after she was killed. Years after she was killed, the case was still in court. The multiple cases were still in court, as were many of the others. So this is the horror of libel suits, for example. They can actually grind you down to that extent that if you put up a fight, but if you know those cases can be inherited by your family, you might think twice. And in Malta, libel cases can be inherited by your family. And so they were. So within days of Daphne's murder, her sons and husband were in court, stepping into her legal shoes and being obliged legally to give a reckoning of the cases against her when their primary witness was dead and they had no access to her sources. I mean, it is an example of how effective SLAPPs can be. The law actually allows that sort of thing to happen. And when you look at the statistics of the cases that Daphne faced, 70%, at least 70%, were filed by governing party officials, including ministers, their associates, party donors. They were mostly filed in the years leading up to her death. So you could, if you plotted them on a graph, you could see a steady escalation just before she was killed. And it seemed almost like it was a warning that something much, much worse was coming. And if you look at it statistically over the span of a 30-year career, most of the cases against her over those 30 years were filed in the last few years before she was killed. And it was a steady escalation all the way up to her death. You know, when you look at the statistics, then you see some other interesting facts. They were mostly filed by men, and most of them in power or their cronies. And there were some cases filed by women, but they were women who were associated with the men in power. So the wives, their assistants, and so on. You know, clearly this was, you know, not just about the law, not just about accountability, but also to some extent there's a degree of misogyny involved. Why would you sort of circle a woman and attack her in that way? But because you can, because the law allows it. And while all of that was happening, she was also receiving threats from a UK law firm, Mishcon Berea, which the firm had been engaged by the passport sales firm, Henley and Partners, and they were issuing threats on a regular basis. And this was being done with the prior approval of the then Prime Minister Joseph Muscat and his Chief of Staff, Keith Schembri, which is significant in itself because their hands were effectively hidden, but they actually approved that kind of action. So those threats never materialize in a court case. But of course, if you were the kind of person to not question something like that, you could very well have silenced her altogether. I mean, she fought back. She published the letters, which, you know, technically they were asking her to not do. And she fought back in that way. But while you are fighting back, there is this threat hanging over your head that you could be sued in a court in London, a cross-border case, you know, which is really difficult to challenge. And the sinister thing is that the firm which was suing her, and that's the Henley and Partners, I mean, they knew there were no grounds for the case, because we know from private correspondence that Daphne had received that the firm was looking for a reason to sue in London, and their London office said there are no grounds, our business has not been damaged. But they engaged that firm anyway, and that firm issued those threats anyway. So there was a lot of people acting in bad faith. And that's an ongoing problem. And I'm really glad to see that the Solicitors Regulation Authority is now actively investigating complaints, and that the UK is actually taking action to work on SLAPPs. And the reason that is important is because, you know, we hear very often that UK is the libel capital of Europe, London in particular. And, you know, that seems a fair description. Why? Because there's an ecosystem in London that doesn't exist anywhere else in Europe. You know, unscrupulous law firms, libel-friendly courts, high costs of mounting a defense. And now, you know, with the exit of the UK from the European Union, you're talking about third country cross-border cases, which makes it that much harder. All of this is, you know, all of this is something that was news to me when Daphne was killed, because we had no idea that SLAPPs were actually a thing. And we found out only because NGOs started to take notice. They looked at Daphne's experience, and they drew a lot of attention to the problem of SLAPPs. I mean, NGOs had already been working on this for years, you know, Article 19, for example, Greenpeace. But it took Daphne's murder, you know, something as drastic as that, to focus public attention on what is a problem across Europe. and a problem that affects not just the defendants in any particular case, but literally everybody in Europe, because if you shut somebody up, you're depriving everybody else of their right to know. And that can happen just by threatening someone. You don't even need to take them to court. Sometimes a threat is enough. You know, what has happened then with this campaign is that some very active NGOs, very persistent individuals took up this issue and worked at it relentlessly, and eventually drew attention of the European Commission. And only last April, the European Commission announced a draft directive to end SLAPPs on any cross-border cases, and a recommendation that has already taken effect across Europe, but cannot be enforced by the European Commission itself. But member states are subject to those, to that announcement, are subject to that recommendation, and are being urged to do something about SLAPPs. We'll hear a lot more tonight about SLAPPs from people who have actually had direct experience, either as targets or being on the side of the law. I'll be glad to take questions later, but I think I've said quite enough already. Let's hear from someone else for now.
Thank you, Corinne. And the element of Daphne's case that alarms me is that the cases after her death were, as you say, passed on to her estate. It's an element that I think is so just toxic, and having to defend while mourning is an element that I think is really quite alarming. And also because Daphne was an independent individual journalist. She was incredibly influential in Malta. Her readership was bigger than the majority of all papers combined, but she was working on her own, and she was breaking big stories in Malta, very similar to Clare's experience. And so I'm going to bring Clare Rewcastle Brown. She's an investigative journalist and founder of the Sarawak Report and Radio Free Sarawak. And she's been subject to SLAPP cases both in the UK and Malaysia related to her reporting that uncovered the 1MDB scandal. Again, it's a massive scandal. There's a Netflix documentary about it, but Clare's reporting really was at the forefront of it. Without Clare's reporting, we probably would not know the extent to it, and she's had to pay the price through SLAPP threats. So Clare, please, the floor is yours.
Thank you so much, Nick, and so wonderful to listen to Cora, and it's been such a pleasure to have the sad opportunity, but to be so impressed by so many members of Daphne's family who've continued this fight. And thank you for doing it on all our behalves. I wish I'd known Daphne. I feel we could have had a really good natter about just what it's like to be taken on by these forces. And so interesting to listen to you mentioning, I mean, the three cases I've most recently been dealt with, and I've had dozens of them, have involved officials, the leader of a political party, an ex-assistant to a senior Attorney General member of the Malaysian government, and also presently a royal sultana who wants 300 million ringgit out of me, which is about $100 million. So those are the sorts of people you're up against, all of whom, of course, are actually public figures who need to be scrutinized and held to account by journalists for the benefit of the public interest. And yet you see time and again. And the other thing that also resonated with me was this use of criminal libel. It no longer exists in Britain, but so many of the countries that have inherited this arcane law still have the criminal libel aspect. And so I am being sued by a royal figure, and at the same time her husband has issued a warrant for my arrest for the same issues, and I'm supposed to be dealing with all of those. If I'd had a chat with Daphne, I was thinking we could have, the idea that she didn't realise what was happening to her was hugely galling, because, I could have said that there's a pattern. It's recognisable. A lot of it can be ignored, but of course the big law firms in London are taking advantage often, particularly in the space we now work, where so many people are blogging away, often bringing out the best stories at the moment via that sort of journalism, which is a very isolated form of journalism. But they will get what is designed to be an extremely intimidating all-round experience. First, there'll be, a very lengthy and aggressive legal pompous letter, which will, they have a sort of you know, toolbox, and usually they throw the whole lot at you: privacy, data, copyright, endless ways in which you've you know, allegedly broken laws against their client, and you know, always you know, citing the same old cases they use. You know, it's a sort of pro forma now. I file them in the bin mostly, but how is someone to know unless they've been through this? You know, what's been done to them. If you do front that up, then the very rich person will consider whether they want to put a little bit more pressure on you. They may very well issue a writ. Usually they don't, because you know, that really gets them much more exposed, but sometimes they do. And then you know, you're into expensive territory. If they can get a writ, and the law allows them to do that as it stands, they can enmesh you in the most hugely expensive interchanges. If you then hire a lawyer, particularly in London, you know, that lawyer will be charging you thousands and thousands. I mean, my legal bills were hitting $1 million by the, you know, would have hit at least $1 million by the time they come to court in London. And then of course you've got the threat hanging over you of should you lose, should you get a sort of awkward judgment. And you know, I can think of several. I mean, Carol Cadwallader is currently facing an appeal, a judgment that was very you know, a very difficult judgment to begin with, that was then ruled against, and she was found for by the courts, and that's now been appealed. This all costs enormous sums of money, and that's the weapon ultimately. The law allows these litigants to cost you money, and their objective is always to use that to shut you up. And you know, the letter will accuse you of all sorts of things, impress on you how they can ruin your life and destroy you financially, and then they will say, but of course, if you remove everything that you've ever said about my client and agree never to speak about him again, we'll not cost you a penny. That's it's the naked threat. You know, you might as well have been mugged on a street corner. In fact, it would be a lot cheaper to be mugged on a street corner. And you know, the language in those letters is always so aggressive, and you know, the misogyny comes out, and you're reminded at the very beginning, untruthfully, that this unrequested letter, you know, full of insults towards yourself and defamation towards yourself, is not to be shared with anybody. It's privileged, they claim. I nearly always share them, actually. I didn't ask for the letter, and I'm under no obligation. I've made no agreement to keep it private. That's my view. So you have to be pretty tough, and you have had quite a lot of gone through this not to be very intimidated. And because you're dealing with usually criminal rich people, they don't stop. They don't stop at the legal letters. You know, you will also find they will have hired a PR company. Very often, that PR company will have been engaged and being paid through the lawyers, which is worth bearing in mind, and something I think the Solicitors Regulatory Authority need to look at. And that PR company may very well be the conduit to the private investigators who're probably going through your rubbish and your mail and looking to find out if you've got anything embarrassing in your life that they can publish, because they will without doubt have probably started an online campaign. I've had several websites dedicated to defaming me, you know, anonymously, of course, and secretly. And Bell Pottinger was behind one of them, a British outfit called FBC Media behind another, a bunch of Swiss private investigators behind another. I've had about 5, and they'll use you know, non-existent Facebook characters and Twitter characters who aren't actually real people but pose as it, to write really horrible things about you and whack it all over your online social media forums. And of course they'll pay Facebook to promote all that. So it's a real aggressive attempt to really, you know, destroy your peace of mind. And you have to you have to know what's going on and be pretty determined to withstand that. And of course, most people don't. And sadly, the weakest often in this game can be mainstream media, because they have businesses to protect. And hemorrhaging hundreds of thousands on genuine, you know, standing up for genuine work that they've done of journalism against these sorts of people, it is a massive toll on their business, and it has a chilling effect. I think, without doubt, you know, mainstream media compromises on stories it shouldn't, doesn't do stories it should, and so forth. And that's something that the wider public should be concerned about, and needs to be aware about. So I think those are, yeah, I mean, you know, if you go on to trial, I found that all this kind of sort of network of people, they start leaking stuff from the trial that isn't in the court. You know, so interchanges between lawyers that shouldn't be made public start to be leaked onto social media, you know, and again, you know, that they're operating in a way that, you know, you're the one who's the subject of the worst defamation, and yet you have no kind of way of going after this kind of harassment, you know, and you know, Daphne obviously experienced the worst possible outcome and form of it, you know, but I've experienced being, you know, in tandem with that, finding myself being blatantly followed, so that they want you to know they're following you, to the extent they'll then take pictures of you at private meetings and then put that online just to say we're watching you. And then of course you get threats and, you know, oh dear, we're just trying to let you know, you know, someone's trying to kill you. And in fact, in one case where I was facing this sort of legal action, I through another source was informed that that person who was initiating the legal action had actually been at a meeting where it had been discussed what to do with me. And the first suggestion was that, well, why don't we bribe her? And when it was kind of generally agreed I might not be amenable to bribery, the next suggestion was, shall we kill her? And it was thought that that could be counterproductive, luckily for me. And so then that was when the legal actions began. So, you know, journalists all over the world face threats if they're exposing really dangerous and unpleasant people like Daphne so bravely did. And how often it ends up being women who do it, but not always. Many very brave male journalists. But, you know, even in Britain, as Nick said, you know, you're put under sort of almost intolerable pressure because nothing is being done to assert the rights of journalists against this kind of harassment. And I think moves could be done, and I'm very grateful to all of you here who are working on that. Thank you for your time.
Thank you, Claire. And I think the idea of the toolbox is a really important thing to look at. There are SLAPPs and there are multifaceted. There are different ways of approaching SLAPPs, but also there'll be other ways. There'll be harassment campaigns, doxing, smears. I mean, as you said, threats of physical violence, all to try to get to the same endpoint, which is the SLAPP, which is to stop someone reporting, stepping back from an investigation. But also how it also isolates people, and both Daphne and Claire have sort of experienced that, how they isolate individuals. And for independent journalists, unfortunately, it's easier because they don't have a newsroom around them. They are on their own working on these issues. But we are now going to talk to Franz Wild, who's the editor of the Enablers Project at the Bureau of Investigative Journalism. Together with Open Democracy, they are currently crowdfunding to mount a defense against libel suits that they're currently facing. And obviously TBIJ is an innovative newsroom, but also are facing libel threats in a manner to try to silence their reporting. So Franz?
Thanks, hi. Yeah, I just wanted to maybe give you an overview of a live SLAPP case. So we wrote an article this February, which we always publish in connection with established media outlets. So we published this article about the Nazarbayev Fund in Kazakhstan, which was established by the former president there. It's an educational fund which has about $8 billion in assets. And we were interested because it seemed to structure a lot of its assets through London. So that was kind of why we looked at the story. And we published something in February and then didn't hear anything. 2 months later, we received a lettable full claim from Boies Schiller, a well-known American law firm. And then I think it was this mid-August, they issued proceedings against us and a number of other organizations. So four organizations in total, 3 here in the UK and 1 in the US. And obviously, you know, these are live proceedings, so we can't really say too much. There's, you know, anything we do say can kind of jeopardize the situation. Obviously, they say we defamed them, we deny that. And we believe this is a slap because this is not something, in our opinion, which where the facts remotely offer a realistic case. Again, I don't want to sort of litigate this here. They obviously deny that our story is in any way fair. The effect on us has been that basically our whole team has been drawn onto this. It's absorbed a huge amount of resources. And together with Open Democracy, we launched this crowdfunder to help basically fight this case. And, you know, we're lucky enough to have other forms of income which will help us pay for the bills. But it's been essential that we do this. And it's actually been incredibly heartwarming because we raised 40 grand very quickly. And we had over 1,200 individual donations, everything from, you know, £2 to £2,000. And it's just been kind of incredible to see that so many people will actually come out and, you know, put their money into this and messages of support and all that sort of thing. And actually, this is something that's riled up a lot of MPs as well. And I think Caroline's going to be talking about this, about some of the previous lawsuits that we've seen. But on Monday, David Davis MP is leading a debate in Parliament where he's going to be addressing this particular suit, but also sort of slaps in general. Just, I won't say much more, just briefly, we're actually currently working on, just to kind of show you how current and active this, all of this is. And just to echo what Claire said, every word of what she says is true. And one of the things that I always find so bemusing is the people who are kind of coming up against you do not play by the rules. And that brings in the law firms, the solicitors who act for them. They, you know, so for example, I had an agreement with someone I was interviewing, that meeting was off the record, wouldn't be recorded. I come back to London, this was somewhere else, and their solicitors send me a letter quoting verbatim from the conversation, having clearly, and citing a recording. So, you know, not only is this happening, but the law firms are part and parcel of this. At the moment, we're close to publishing, or we're working on a story. We've received 11 letters, not from the people we wrote to, but from their lawyers. So, you know, this is public interest journalism. This is holding powerful people to account. We're asking them questions, and they're responding with a letter which says, not for publication, private and confidential, you're not allowed to tell anyone about this, but we might sue you if you get anything wrong, or, you know, they're just immediately raising the stakes to a level that just feels slightly uncomfortable, but we'll just have to crack on.
Thank you, Franz. I mean, all the speakers so far have talked about this. You know, it's the intersection between journalism and law. And also hovering around there is this idea of access to legal representation, access to knowledge as to how far you can go, how protected you are, and how that means how willing you are to maybe push back and defend your reporting, or maybe having to step back depending on the circumstances. So now we're really delighted to have the sort of the legal side of the conversation, as it were. And I'm going to introduce Caroline Kean, a media defense lawyer and founding partner of law firm Wiggin. She's acted for HarperCollins in the cases brought against the publisher and their authors, Catherine Belton and Tom Burgis. You may have seen these very high-profile cases recently in UK courts. So, Caroline.
Thank you. So I come at it from a slightly different angle, but I've been doing this work for over 30, 35 years and worked always with defendants, publishers throughout. The tenor of the claims has changed. There used to be more libel actions, but they weren't nearly as vicious and professional as they are now. And I think you can date the change to when law firms started branding the work that they did, not as defamation defense, but as reputation management. And that sparked a whole new industry. And as people have already said, bringing in private investigators, which I think is the most insidious part of this, but also bringing in PR people and conducting very coordinated, well-financed, targeted campaigns against people. Because the difference with libel to any other cause of action in this country is it doesn't just affect the people involved. I think Claire's already touched on this. It's not like a boundary dispute where you and your neighbour are falling out over the hedge. What happens in these cases affects everybody because of the knock-on, what we always refer to as the chilling effect. If somebody knows that a certain claimant is bringing proceedings for good commercial reasons and good personal reasons, people start going, I'm not going to go there, I'm not going to touch that story. And again, as Claire mentioned, this is as true of the media giants as it is of the individuals, because again, it's not just that they're commercial organizations, but they have other people's jobs at stakes. And these cases, defending these cases, will cost an extraordinary amount of money. And you've mentioned Catherine's case. For those of you who don't know, Catherine wrote an amazingly well-regarded book called Putin's People. And virtually immediately after it was published, Roman Abramovich surfaced complaining about what she'd said. There was a certain amount of correspondence with us saying, basically, in lawyers speak, go away. The letters always go over 4 or 5 pages when you're saying go away, but that was the thrust of it. And it went very quiet. And so we thought, that's fine. As we found out later, in January, the year after publication, Navalny in Russia had held up a copy of Catherine's book on his YouTube channel and said to everybody, if you want to know what's going on in Putin's Russia, read this book. And we understand and have no reason to disbelieve that that so incensed Mr. Putin that he got a series of his pet oligarchs to start making complaints to take the book down. So Catherine suddenly was faced with, I think in the end, a total of 7 claims. Not all of them were issued proceedings, but something like 7 claims targeted at the book. She was very lucky in that she was published by HarperCollins, who are obviously part of Murdoch's empire, but also have a very genuine commitment to supporting their authors and did have the muscle and the money to do it. And one by one, we picked off those cases and we got rid of them. And then, as you mentioned, their other author, Tom Belton, who'd written a book exposing corruption in a different set of oligarchs, they issued proceedings and we managed to use a legal device applying for a trial on what we call meaning to get the whole claim struck out. And it's one of the very, very few occasions where you've been able to get the claimant to pay your legal costs. And boy, did we make them pay. That was a claim where the court was very scathing. What had happened was that a company had decided to sue over the allegation. It said that the book meant that it had murdered people. And we went to the courts going, a company is a legal fiction. It cannot murder anybody. I mean, frankly, it was a lot more complicated than that, but that was the thrust of what we were saying. And the judge said to the claimant's barrister during the course of the hearing, but, you know, the directors, the people behind the company, they're obviously the ones that make the company do things. Effectively, why are they not bringing proceedings? Because, you know, they could have murdered somebody or given directions for them to be murdered. And their barrister had to give the answer, we decided not to. Now, of course, they decided not to, because they issue libel proceedings. That gives us the scope to do investigative journalism with the protection of privilege and to open up to scrutiny. If you're as privileged as Tom was, to have a publisher that can back you and help you do this. But they didn't want to do that. They were cherry picking what the allegation would be. And I'm very pleased to say that for once, the English court sent them away with a flea in their ear. So a couple of other points. Why does this happen here in the UK? It's partly because England is seen as a very credible jurisdiction. If you can get a decision here, that will be rolled out worldwide. And it is partly because of the way our laws are framed. So if you're not a lawyer, quite often people don't know that if you're the claimant, you don't have to prove that what is said about you is false. The burden, unlike any other case, it's not innocent before found guilty here, the burden switches on the defence to prove that what you said was true or honest opinion, or in the cases that we're talking about here, in the public interest. And again, what normal people don't realise is that in the public interest defence, it's the journalist that gets put on trial. They have to show why they reasonably believed that what they published was in the public interest. So you lose the focus from the person whose corruption you're exposing. The focus all becomes on you and what you did, and why did you believe that source, and why didn't you ask that extra question 10 years ago that you might have done if you'd thought of it with the benefit of hindsight, which is why these things become incredibly expensive, and why it is even more difficult for journalists and stressful for journalists than any other cause of action. I've probably said enough about this. I know Susan is going to get on to the work that's been done in getting the Solicitors Regulation Authority on side. I can confirm personally, they are being active. They're even coming to audit us, and we're only defendants. So they are going around taking this very seriously. And one last point before I forget is when you get those letters saying not for publication without prejudice, it's strictly private and confidential, you write back to them and say, you're not entitled to do this. I do not accept this. I am not dealing with this letter unless you send it me in open, and I've got the right to publish it anyway. Don't take it on the chin, call them back.
Thank you so much. And I'm also going to use my chair position by recommending both Catherine Belton and Tom Burgess's books, because they're both very, very excellent. So we've sort of tried to sort of scale in from the impact from journalists and looking out and sort of echoing out. And now we're going to pass over to Susan to talk about, because we've all talked about this being a systemic threat to journalism and public watchdogs, but also, so in that respect, the response needs to be similarly systemic. So Susan Coughtrie is the Deputy Director of the Foreign Policy Centre and co-chair of the UK Anti-SLAPP Coalition. And she's a lead author of the report, London Calling, the issue of legal intimidation and slaps against media emanating from the UK, which is also a very good report, which you should also read. And so here's Susan.
Thank you, Nick. Well, I just wanted to say that it's probably been a couple of years since we've been researching SLAPPs at FPC, and I think Daphne's case was certainly one of the early inspirations for that. We had actually started the Unsafe for Scrutiny project, which is the project I lead at FPC, to look at all kinds of risks and threats to journalists who work specifically on financial crime and corruption, like Daphne did. And we were particularly interested in the relationship with the UK, not from the legal angle originally, but from the fact that the UK has become such a hub, unfortunately, for laundering dirty money, and its financial and legal services are being abused in this way. And so we had seen that there were journalists who were working in countries like Kazakhstan, like Russia, Azerbaijan, countries who, not known for their media freedom, sadly, and known for their corruption, and their political elites were sending their money here. So one of the first things that we did, because at that point, the UK had identified promoting media freedom as one of its main foreign policy objectives, was to show this link and to encourage the fact that actually you need to take action on corruption, put in place anti-corruption measures to also impact media freedom. So we ended up conducting a global survey with journalists who work on this area in particular. We had 63 responses from journalists working in 41 countries. And while we don't ask them about all the kinds of risks they face, so, physical threats, digital surveillance, kind of things that Claire and Franz were talking about, it was overwhelmingly, from the respondents' point of view, the legal challenges that made it the most difficult for them to be able to continue their work. And that's really because ultimately it would put them out of business. So even if they're being physically attacked or surveilled, they could deal with that, but they couldn't deal with the legal cost. And probably the most alarming finding of that survey was that the respondents pointed to the UK as being the international leading source of those legal threats, almost as high as the threats coming from EU countries and the US combined. So for us, that was a really massive flag that more needed to be done in this area. So we published that towards the end of 2020. And at the start of last year, in January 2021, we founded the UK Anti-SLAPP Coalition. And we're very fortunate to sort of build on the shoulders of work that was already being done in Europe in a coalition that's now sort of formally called CASE, the Coalition Against SLAPPs in Europe. And we started looking at what work could we do specifically in the UK. I have to say it was a slow start. We found that the word SLAPPs, while it's got a longer history in Europe and in the US, it really wasn't known here, even by those who understood the experience, who were facing legal threats. It wasn't really known. And we started by really trying to set out the stall by kind of identifying the problem, and many members of our coalition, freedom of expression groups like Index on Censorship, Article 19, RSF and others, started highlighting cases. There was a lot of public statements in support of Catherine's case, Tom's case, and others, Claire, who's experienced some more recent cases as well. And we started looking at solutions, and also very much thanks to our third co-chair, Charlie Holt, who's in the audience here, and is a sort of legal eagle. We started looking at what could be done within the current system. We had a couple of roundtables with media lawyers, including Caroline, and we really came to the conclusion at that point, which was about a year ago, that there were some things that could be done in the UK in the existing system, but really for a kind of wholesale effective change, we needed a new law. And kind of similar to some of the initiatives within the EU Anti-SLAPP Directive, that law needed to bring about an early dismissal mechanism to sort of really get rid of these cases at an early stage, putting in a very high public interest threshold, and making basically taking the sting out of any potential sort of legal threats and things like that. I'd say that momentum was building. David Davis was mentioned earlier. He and Liam Byrne from the Labour Party co-sponsored a debate in Parliament at the beginning of this year in January, which really kind of, I think, garnered a lot of sort of wider political attention at that point. But undeniably, it was the invasion of Russia into Ukraine in February that really accelerated interest in this issue and sort of snapped it into sharp focus. And it was only a week, I think, after the invasion that the Ministry of Justice launched a call for evidence and a consultation on SLAPPs, citing our research and also some of the research of Case. And so we were really pleased to see that. And we were also pleased to see that it wasn't just a case of calling for evidence, but also looking at potential opportunities for reform. Since the first report that I mentioned was published, we continued researching over the last year, and it resulted in April in us publishing London Calling. It's a pretty hefty report. And I think really the aim was try to pull some of the cases into the spotlight. As been mentioned, all of these cases start with legal letters, marked invariably private and confidential and not for publication. And so I think the greatest challenge when researching it was just getting people to talk to us in the first instance. If they'd had a legal threat and they capitulated, understandably, because of pressure, then no journalist really wants to tell you that they've let go of a story and, you know, they've put it aside, that they've been threatened. If they had dealt with the legal threat and they'd moved on and they were glad that it was over, then they also didn't really want to reopen it, and they were worried about sharing information might reignite some of the legal action against them, which, you know, we have seen some of that pushback. But ultimately, the report covers 8 cases that reach the court stage to some degree or another. And a common hallmark, apart from them being extremely expensive and drawing out the procedures over a long time, because it takes quite a long time to go through the UK courts, very few ended, I mean, really only Carol Cadwallader's case ended in a trial, because ultimately the kind of how SLAPPs work is the process is the persecution. Just dealing with the case, as we've heard, you know, Corinne talking about Daphne and also Claire and Franz's experiences, it diverts you from doing your job, and you have to put so much time and effort into fighting it that that's success already for the person who's pursuing you. Some of the lawyers that we spoke to were explaining that it's $500,000, you know, even to get to court. You know, it's actually, the court cases are one thing, but the other side, the other sort of 20 cases or so that we touch upon in the report is really before things have got to court. It's the legal letters, it's the system of the private and confidential letters. And that's something that we feel has really started to become exposed and had a spotlight on, and it's hopefully having some effect. So with regards to the consultation that the Ministry of Justice held, they released their outcome report in July, and the UK government made a commitment to legislating, which we were very pleased, obviously, to see. We had submitted as part of our response, as a coalition response, a draft model law. Now we've developed that even further, and really now we're going to launch it, looking at Charlie here, and we'd like to see that being taken forward. With regards to the regulation that's been mentioned, we're also very encouraged by the action that the SRA have taken. They've opened investigations into 28 possible SLAPP cases in the last few months. They're doing a thematic review, which, as Caroline has mentioned, resulted in them going into law firms and really asking those important questions about how they've behaved. Because I think that's a really key point. Often there's been concern around conflating lawyers with their clients, but it's the tactics they use, the abusive language, and those kind of things that they should be held accountable for. And they've also taken up one of the recommendations in the report, which is to produce some standalone guidance on SLAPPs in the form of a warning notice, which would go out to all solicitors. They have to be educated on it, and then it forms a basis by which stronger regulation can be taken forward in the future. So I think from where we were at the start of last year to now, we've seen a huge leap forward. We need to see some of this stuff put into action, certainly laws adopted. But I think it's very encouraging to see what's been possible in coalition, both here and obviously in Europe. And so yeah, I'll leave it there, and maybe if there's any questions.
Thank you so much. I've got a few little questions to start things off, and then we can open it up to the audience. So I'll give you some time to think about the perfect wording. Just Caroline, I'd like to go back to what you were saying about the idea that there's always been sort of defamation threats, but something's changed, and there's an evolution somehow. And we're seeing, that defamation used to always be seen to be the threat that journalists should face, but now obviously there's GDPR, privacy, data protection, things like that as well. So in your mind, what do you see? What is, in your view, how has SLAPPs evolved, and how can we how can the forces trying to protect against SLAPPs keep pace with how they're evolving as a device to silence watchdogs?
That's quite a lot to unpick. How has it evolved? I mean, partly it's the law has evolved. I mean, when I started practicing, there was no privacy law in this country at all. That was introduced in 1998. And then you have judge-made law. So you have the first case, and then they build on that, and they build on that. And unfortunately, most of our privacy law is based on shagging footballer stories, and the outcomes in those cases then get applied into more serious cases because the claimant relies on that previous precedent, and so you're into a vicious circle, and you need a law to break the code. GDPR again is something that is completely new. What you have are some very seriously clever people who I think originally, I'm going to, maybe naively, but I'm going to say, I think originally they wanted to do the best by their clients. And they've got onto, almost a circus of how to do it better and more clever and with more money from people. We talk about these SLAPPs letters that we're talking about, and one of the defenses that the solicitors will offer is that I'm only putting forward my client's case. To an extent, that is true, but libel particularly is a very, very complicated area of the law, which again is why it becomes so terribly expensive to defend it. And one of the letters in the Belton litigation was from very famous firm of solicitors, and it was 17 pages long. It went through all the passages in the book that they said were wrong, why they said it was defamatory, and all the rest of it. Now, that particular letter, that particular claim boiled down to 4 particular allegations. And when it went to court, the judge ruled that 3 of the 4 were not even arguably defamatory, had to be struck out. The last one, maybe there's something in it, so we'll sort of maybe let it go through to the next stage. We settled it on the back of that. But what makes me angry, and the reason why I'm raising this was a specialist firm that really understands the law of libel. And they will therefore have had to advise their client, because they won't have been negligent, that these are bad points. And even if you're an oligarch, and it isn't just oligarchs, I mean, oligarchs were very convenient because with the war in Ukraine and the oligarchs, it's focused the government on this. But this applies to people involved in cladding scandals. It applies to NHS negligence. It's all over the place. Those people are not libel experts. More than maybe any other branch of the law, you're relying on your lawyer to advise you. You know, this isn't somebody where somebody hasn't paid you for the goods that you delivered to them. This is extremely esoteric. So what makes me angry is that these specialist lawyers are crafting letters that they must have known were bad in law. And that is what needs to be stopped. They can't continue to hide behind, oh, I'm just putting forward my client's case. That's where the SRA has come in so powerfully. And I think that will make a difference.
Thank you so much. I think I'm going to bounce to Claire here, because we've talked about this sort of network of enablers from the very specialist law firms through the PR companies, the private detectives. I mean, just when you've got this army of organizations against you, how do you keep your ability to keep writing and keep doing your journalism while also dealing with these cases seriously? Because you need to, you know, treat them seriously. How do you balance those two when it feels like you against the world? I think you're muted, Claire.
So sorry. Yeah. Yes, it can feel like that. And really interesting listening to Caroline, because I think that, you know, the evolution here is sort of kind of in tandem with so much of what investigative journalists are coming up against, which is this, you know, this global elite who have more money than countries and corporations, individuals with bottomless pockets. And what you're seeing is these law firms are kind of after that money. Just look at the advertising. I mean, it's revolting that these law firms are now indulging in. It's not your old-fashioned, you know, gentleman's law firm sort of kind of profile that they used to adopt. You know, they're out there. Reputation management, as they call it, comes under the section of these law firms that describe themselves as serving ultra-high net worth individuals. It's the oligarch segment of the firm, and these particular law firms have actually restructured themselves for this lucrative market of a handful of people who they want to just service in every way. And one of those services that they provide, along with sort of, you know, they'll even look after your house and introduce you to a concierge service and all the rest, but one of them is getting takedowns for you, i.e. reputation management. So that's the ethos behind this, you know, that sits really uncomfortably in what should be a hallowed profession, I think. And I'm glad to hear Caroline highlighted. And you know, I'm you know, what it's designed to do is to take up your whole day as a journalist fighting off these spurious attacks instead of getting on with your job, which is writing articles and researching them. And whole newsrooms can be bogged down. I mean, I'm you know, I feel for, there's one particularly wonderful investigative team in a major British newsroom that I've been talking to recently. It's just, you know, it afflicts them all, but you know, all their time is taken up with cases such as this, you know, while they're trying to get on with broadcasting to the rest of us what we need to hear about. It's pernicious, and it's kind of reflects something that's happening in our society, and we need to catch up with it. Our leaders need to catch up with it, and pants on it.
Thank you so much, Claire. I mean, obviously, we've all talked about the increased sort of visibility of SLAPPs and the need for responses. And obviously, Cora, I mean, from the darkest moment in Malta's recent history, the murder of Daphne, there has been an upswell in public calls for justice, accountability, transparency, and the rule of law in Malta. So how do you see the public responding to the increased visibility of SLAPPs? Are you sort of heartened by this maybe being a pathway to a better rule of law for you in Malta, but also across Europe?
Well, across Europe, it's unfortunate, but I feel more hopeful for what would happen across Europe than what will happen here. Our government has announced that Malta is going to be one of the first countries to have anti-SLAPP legislation, but they're not acting in the right direction at all. And the Journalists Union here has actually called on government to act properly on the matter, saying we should be setting the gold standard for Europe, not acting below par. But there's so much about local politics over there. Yes, there is more attention across Europe, and that's thanks to some really dedicated individuals and this network of NGOs that's formed a coalition and has worked tirelessly to raise awareness, to lobby for change, and to see that, to see an end to SLAPPs in Europe, in effect. That coalition formed, it is a bit nebulous to me because I can't remember it forming, but it sort of seemed to form naturally. And now there are dozens of organizations working in that organization. So yes, I am hopeful, but it won't come without a fight. So there are differences of opinion across Europe about whether SLAPPs actually exist, whether they are a problem, whether you can legislate against them without infringing on everyone's rights. It's always a question of a balance of rights, isn't it? You need to make sure that defendants are protected, but you also need to make sure plaintiffs' rights are protected as well. So it is a tough call. The directive we mentioned earlier, that is a positive step. That's the minimum standard we would expect to see across Europe, but it's going to be a while before we get all the countries in Europe to agree on what should be in that directive. And at the same time, the coalition is also working towards seeing a recommendation by the Council of Europe, which will obviously have wider impact across the European space.
Thank you, Cora. And similar to question to you, Franz, because as you're talking about your crowdfunder and how quickly you reach your target and how many people, what's that shown you about sort of how you approach your investigation, but also the current libel action you're facing? Are you optimistic?
Yeah, I mean, I have to say it's been incredible to see the last couple of years. I mean, not least because of the work Susan and Charlie have been doing and many others. There really has been a lot of awareness, but I think also Belton, Burgis, Cadwallader lawsuits, and Carol in particular, she's got such a huge following. She's a real icon for a lot of people, and I think there's a lot of people out there who really believe in truth-based journalism and public interest journalism. And if you look at sort of what's happening in the country, there's a real need for accountability. There's a real need for that kind of journalism. And so I think, I do think people are more willing to stomp up, as you can see in our crowdfunder, but also just to support in other ways. So overall, and the response from government is a case in point. And obviously now we've got a new government, we've got a new Minister of Justice. We've got to see what are they actually going to do? Are they going to keep up the momentum? And I think there is going to be a lot of pressure on them to do that. Obviously, ultimately, across society is probably still a niche issue, right? So the extent to which this is a political matter really is questionable, but I think it has definitely sort of shot up the ranks a bit. If I could just make a slightly unrelated point, coming on back of what Caroline said about how a lot of these lawyers in their legal letters are so blatantly oblivious to the actual law. I mean, one of the issues I have is how they're oblivious to the actual truth and the facts. And obviously what's important for us as journalists is using facts. And if we get it wrong, we're in big trouble. We might lose our house. I suppose in other jurisdictions where it's potentially a criminal act, go to jail. For these lawyers, there's absolutely nothing on the line. If they get it wrong, there's absolutely no consequences. There are no actual standards, and that's something that I think is a major issue. And I know the SRA is obviously taking it far more seriously than they were. But then there need to be some kind of standards of truth that, so for instance, if a client says, oh, well, actually XYZ is true, and they're saying ABC, well, the solicitor has to do some sort of check or their name is on the letter. So they should in some way be accountable for the content. And often it just seems like they're not. They're just saying anything, and then the next letter they'll have dropped that entirely and say something totally different. So that's something that I think needs to be taken care of, and in particular because journalists are obliged to take what they say at face value, even if they have a mountain of evidence that points in exactly the other direction. We have to then say, very high up, say, oh, but he, so-and-so respondent actually says something, the sky is pink. Everyone knows it's not, but you still have to give them that kind of space.
Thank you so much. And you talk about legal letters. There's always the excitement of when you see a legal letter and there's no name, just the law firm's name. So you can't even track who said it was the same person you spoke to last time, just that sort of mind games almost. I'm going to open up to the floor. So if anyone has any questions, I can come sort of toddling over to you. Yes, as far away as possible.
Thanks very much. Is the public interest defence not quite strong in its own right from a journalistic perspective and a legal perspective in pushing back? Second question, if I may, just to leave it with you, but I'm usually quite sceptical of the ability of regulators to do anything about this sort of thing. What explains the SRA's getting off its arse, as it were? I know you've already touched on that, but just what explains the momentum behind it, if possible?
So maybe we could go to Caroline for the first and then maybe Susan for the second, maybe?
That's what's so insidious about it. On the face of it, Section 4 looks really useful. Yes, you have got a defence. If something that you've published is in the public interest and you've taken reasonable care in what you've done to check it, doesn't matter if it's not true. It's our catch-all defence. You'd always go for truth if you can, but it's very hard to prove the truth of things. So on the face of it, yes, it looks great, but the way it's drafted, there is a clause subclause in it that says that the publisher, the journalist or the publisher, has to have reasonably believed that what they published was in the public interest. And it's those words, reasonably believed, that are the flaw in that section, because that means that the claimant puts the journalist on trial as to the basis of their reasonable belief. And that means that opens up all the things that the journalist did to investigate. They will, you're absolutely right, but what will happen in the end in a court, the journalist will be giving evidence with an extremely experienced QC who is incredibly good at cross-examination, who will hit on one word, for instance, in one sentence in a 600-page book and start drilling down into why exactly did you use that word. Now, I'm not saying that you can't run a successful public interest defence. Of course, in theory, you can. But when you have a book, let's take Catherine's book, for instance, which has got more than 10 years worth of research. She has got sources that she cannot name because obviously they've given evidence to her at risk to themselves. They will not come to court. We wouldn't expect them to come to court. Now, again, English courts will recognise that you have to have confidential sources, but they weigh in the mix the value of that evidence. So if you haven't got the source coming in to say what they told you, they then go further down into, well, why would you believe that source? And maybe they've got an axe to grind. And what else could they have said? Why did you accept it? Why didn't you check that with the claimant? And of course, you have written to the claimant and asked for their version of events, but quite often they've either not replied or they've given you a load of the sky is pink that you then have to make a judgment call on before you put in. But this is all amazing material for the claimant on disclosure from you. They want a huge amount of the material that you're underpinning your book with, and cross-examination. It isn't that you couldn't succeed, but on a piece of work that's at all complicated, to do that all the way through for 1 to 2 years, having everything that you thought and you did subject to scrutiny from your own side as well as from them, because before you put your defense in, you need to see where are our weak spots, is immensely difficult. Well, yes, but to get there, the cost and the stress, which is why, again, so many of these cases don't go to trial. Most of what happens is legal manoeuvring to get to a position, as indeed we did with Catherine's thing, applications to the court that move the goalposts a bit so they see it's trouble for them and you get out of it. I hope that answers.
If you don't mind, I might just add to that point in particular, particularly because I'm not a lawyer. So when I started researching this, some of the sort of thinking around, well, if you've got the facts, then sort of what's the problem? And I think Carol Cadwallader's case is a really good example, and write about it in the report on this aspect, because I mean, ultimately, Carol won her case. I know it's being subject to appeal, but she won it, and the judgment came out this summer. Aaron Banks filed in the summer of 2019. So it's been 3 years from the case being filed to the judgment, and she won. But the other fact is that there's all these stages in between. And so the first stage, and Aaron Banks actually filed 4 claims, and there was a meaning hearing in December 2019. And the way that the law works now is that there's a single meaning decided upon by a judge at that stage, and that's the truth that you've got to prove. And so that's inference in a way, and it's a bit artificial in the sense of the judge has got to decide what he thinks the ordinary reader would take away. And so the ultimate sort of sentence of meaning that Carol had to kind of come up against was not a sentence she'd actually said. And so, and interestingly enough, 2 claims in that meaning hearing, the judge decided that what Banks was putting forward was basically far-fetched. And so he withdrew those 2 claims, but the 2 that preceded, Carol would then have to prove the judge's meaning. And that's ultimately why she dropped the truth defense. And then that fed into sort of a bit of an online smear campaign, in the sense that, well, Carol doesn't believe what she's written or said because she's dropped the truth defense and is relying on public interest. But actually very little in the discourse was then about why that truth defense was dropped. So yeah, sometimes you think, well, got the facts, it's straightforward, but it's not. It's more complicated than that. And then, of course, there's the other point that Carol mentioned, Caroline mentioned, was that there's the length and the time it takes. And one other example I wanted to speak about was the case of Paul Radu, who's the co-founder of the Organised Crime and Corruption Reporting Project. And he was sued by an Azerbaijani MP and businessman who was named in a publication produced by OCCRP in 2017 called the Azerbaijani Laundromat, which uncovered that 4 shell companies were being used, the British shell companies were being used to siphon millions, not billions, I think, out of Azerbaijan into, through the UK. When the case was brought by this MP, who lived in Azerbaijan, he was sitting MP in Azerbaijan, but he had established enough of a reputation, which is still quite a low bar here in terms of owning property and sort of having some residency. They continued investigating, and they uncovered more information in the run-up to the trial. And because of the nature of the UK law, they also had to disclose that prior to the trial, and then the MP decided to withdraw, and they settled. And the information, the original reporting stayed online, and I understand maybe that their costs covered, but they ultimately decided to do that because they couldn't take the risk. They'd already had to raise, I think, $500,000 to take it that far. And so they decided to settle. This year, in January this year, so this is 2 years after that case concluded, the National Crime Agency successfully seized about $5.5 million of members of the family of the Azerbaijani businessman who had sued Paul Radu in relation to the fact that they had been involved with the Azerbaijani laundromat. And I think, you can see this is even 10 years on now from when this crime originally happened. And a lot of what you do see is that it's journalists who are at the forefront of uncovering, the financial crime and corruption that goes on. And sadly, because the law enforcement institutions here in the UK are not well resourced enough to take on, and prosecute these people, then when journalists get to court, they don't have that backup of a legal judgment against the people they're investigating. So it's a terrible kind of loop, basically. And certainly and that's why, of course, journalists are gone after, because the people don't want that information in the public domain that could then end up in due diligence systems or in law enforcement. To come back to the point about the SRA, so we've been sort of engaging with the SRA over the last couple of years and encouraging journalists to report complaints to them where they feel that these letters have crossed the line. But the problem is sort of twofold. One is the SRA didn't really have guidance. I mean, the first time that SLAPP system mentioned their guidance was this year in March. And speaking to journalists, either they hadn't complained because they didn't think that the SRA were going to do anything because there was nothing within in the guidance to imply that they would. And moreover, the complaint system almost set up as if you've hired a solicitor and you're unhappy with the service that you've provided. So, the suggestion you might then complain to that law firm before contacting the SRA, which was not the case, but some journalists said that they thought that's what was implied that they had to do, of course, was not going to get any results. And if you've been through a legal kind of situation and maybe you've seen it off, I think you've moved on and you want to spend your time and energy dealing with the next investigation and getting past it. But I would very much emphasize that the SRA have now stepped up and they are engaging. And so if there are people listening who've had legal letters or concerns, now is the time definitely to get in contact with the SRA. They're conducting this thematic review. They're interested to hear from people. And so, it's a good moment to submit any evidence that you have.
Thank you. And before we open up for, I don't know, Corinne or Claire, do you have anything from any of those two questions you want to so bad? I want to make sure we're not cutting you guys out.
Well, yes. We've both jumped in. You go ahead.
No, it's just one small point I'd like to make is that we're talking about journalists. So journalists are the most targeted group where SLAPPs are concerned, but other groups are also affected. So if you look at the statistics of the data collected by the Coalition Against SLAPPs, most of the cases identified involve journalists or editors or media houses, but activists are also targeted and academics as well.
Yes, a couple of points, and we talked about how there's this sort of sense of impunity that these smug solicitors who come attacking you seem to have. Nothing's ever they can do what they like, nothing's going to ever come back at them. Another great advantage they have is that they seem to be under no real obligation to check on the sources of the money that they're being paid with. And in some cases, I've been able to prove that money going to famous British law firms from mega crooks, known and recognised mega crooks from whom cases have been won against, Joe Lowe, the architect of 1MDB in this case, law firms were receiving that money, and I was able to trace how it had been stolen and forward it to them. It's water off a duck's back. There seems to be no retribution. They just sort of say that their internal due diligence is satisfied. And that's an issue. And then just quickly on meaning, I mean, I've been sued by a political leader whose name I've never mentioned. I'm being sued by a royal figure who claims that I have meant the most unbelievable, I mean, jaw-dropping interpretations of something that any English reader would regard as a totally innocuous statement. Yet, you know, you still find yourself dragged through these wild interpretations of your meaning, and can get hooked on it if you know, if a decision's made against you. Yes, you know, these are the issues. And one last point, again taking up an NGO that I've been in touch with, again finding it very tough going in a court for the very reason that NGOs and journalists are indeed relied on now by the world. Oh, wonderful, the NGO, wonderful, the journalist went and just, you know, and publicized a disgraceful scandal, but had been ignored resolutely, despite it being in plain sight by regulators all over the planet. I mean, that's what we do. We see what, you know, because the regulators so often are just not funded to do it. So no, there isn't a case yet against the person that NGO had identified. And the judge, you know, is then, you know, only too prone to say in court, well, you know, there's no evidence that's been found by any official channels against this particular individual. You know, so how can I, you know, how can I believe what you're saying is true? So these are, you know, this is the treacherous path that you, the journalists, the NGO, the activists, find themselves treading, you know, for very little money. None of us do it for wealth and fortune. You know, we do it largely in the public interest, and someone needs to be doing it. And this is very effectively stopping this very important work that preserves democracy. And it's an assault. It's one of many assaults on democracy.
Thank you. And to Corinne's point as well, I think it is important to notice there's a lot of SLAPP actions being brought against environmental defenders in Ireland, North America, South American countries, pro-transparency, anti-corruption organizations. I think there's a hearing in US Congress when it's sort of highlighted the use of SLAPPs by oil companies, extractive companies against NGOs and campaigners as an important point that shouldn't be omitted, but also, you know, also highlighting the threats to journalists. Are there any other questions? And we also have people online, which I totally forgot about. So I don't know if they've got any questions. Any in the room? Yes. And then maybe you can sign if there's any from our online people as well.
Thank you. Just to clarify, if anyone knows exactly what the SRA is capable of doing to these lying, treacherous law firms once the SRA establishes that the law firm has indeed been lying, you know, for the interest of its client and quite transparently, what is the punishment? Thank you.
Thank you. So yes, what can the SRA do if a solicitor has violated the rules when they are in place?
They can fine, or ultimately they could strike you off as a solicitor, which is pretty dramatic. Sorry? Not in terms of libel letters, but it does happen rarely, but it does happen. The other thing to remember is that we're officers of the court as well. So you could be done for contempt of court if you're presenting a false case, and that would have a criminal sanction. That's there as it is.
Just to add to that, I think one of the reasons it doesn't really happen is that you can do quite a lot, but before you reach a threshold where you might incur a fine or serious action, you can still say a lot of things that are going to seriously set back a journalist.
And I think they really haven't focused on this at all in the past, and it is now under scrutiny. And they do see that a lot of the credibility of the profession is at stake here, again, because of the Ukrainian war and because of the oligarchs. Do you think that's fair, Susan?
I think for the first time there is a reputational issue. I don't know if this is the reason that the lawyer who was representing Elliot Higgins, well, the person who was suing Elliot Higgins earlier this year, but Elliot Higgins is the founder of Bellingcat, which is an open source investigative media outlet, and he was being sued by a Russian oligarch, sort of friend of Putin, and who's been on the sanctions list already for a couple of years. So this was before the recent invasion, and he was still able to sue or to start litigation process against Elliot Higgins earlier this year for tweets, by the way, that Elliot had published. And after, I can't remember how soon after the invasion, but the person representing Prigozhin decided to withdraw his services. Now, I don't know if that was why, but I do think it was an interesting occurrence. And certainly there's been a lot of discussion, I'd say now, within the legal profession on this. And it does seem that perhaps there is now a reputational risk in representing some of these people.
I was interested how you would describe the pursuer against Elliot Higgins, to be honest. I think if the SRA does move forward on this, this will be something that they can be held to account to, like they do with their other regulatory. So we need to get it in and then sort of follow it and keep sort of making sure they are using all the powers when needed. So thank you. Any more questions? Do you have one here?
Thank you. I can completely understand the merits of going after the lawyers in a regulatory sense, but is another potential avenue of redress in this regard kind of going after the claimants as vexatious litigants or some variant thereof?
Thank you. I think maybe we'll go to Claire on that one first, and then Corinne, if possible.
Well, I remember once being so absolutely furious at some really awful defamation against me that I mulled taking legal action as opposed to merely defending myself against it in all directions. And one lawyer I consulted said, you know, you'd be better off setting your hair alight and putting it out with a frying pan than, you know, bringing any kind of legal action. I mean, you know, the money involved in taking legal action is prohibitive, and I have been sued for libel, and I mean I have been thoroughly libeled in the mainstream media, and was advised, you know, that you're not rich enough to sue for libel, and that's something we haven't talked about tonight. This is a rich man's law. It's not available to anyone else. Nobody else can protect themselves from libel. That's why you see newspapers happily going after priests and, you know, celebrities, you know, who only have sort of sofa type salaries, and you know, teachers, you know, therefore fair game. We can all hear horrible stories about them because, you know, the newspapers know they won't sue for libel. They can't. You can, of course, go, and I have done very effectively. We do have organisations such as Ofcom and press complaints, and frankly, that's where these litigious billionaires should be taking their complaints as well.
Thank you, Cora. Would you like to contribute to that question at all? Or I think you're muted.
I'd just like to add to what Claire said about how people go after, you know, how media can sometimes go after the sort of little man. It certainly, there was a case with Daphne, is that she was roundly abused by media, which are controlled by political party, and they knew that she would never sue for libel. They knew that. So it is abuse. It's an entirely systematic form of abuse that, you know, people are protected by a system that is entirely legitimized because the law supports it. But it's also the result of practices that evolve over time. So it is easy to go after people who aren't going to sue. It's a lot harder to go after the people who should be sued because they're acting abusively.
Thank you, Caroline.
I've just got one point, Claire. You can get no fee agreements for libel here if you haven't got the money. So it isn't only a rich man's game, but you'd have to have a pretty good case for somebody to take it on that basis.
Yeah.
And in Scotland, you can get legal aid for defamation, but it's incredibly rare. We do have some questions from the online audiences. You're going to have to put up with my voice, I'm afraid, while I read them out. So this is Malin Kroner. As you all mentioned, SLAPPs are quite demoralizing for everyone. Are there networks for lawyers that want to stop this as well? Or is it mainly publishers and journalists fighting against it? And I will say we've only got about 2 more minutes. So I'm just going to go, if anyone raises their hand that they want to answer that question, and then we can go on to the next question. So does anyone want to answer Melon's question? Caroline?
There aren't networks as such, but there are some of us that are good guys.
Excellent. Maybe we should form a network and then just made up of the good guys. Thank you. So, and another question here from Margarita Omodio. Apologies for the pronunciation. Has there been any concerted effort to inform the general public of what SLAPP is all about? Most people don't understand what it is or how far-reaching its significance can be. Anyone want to answer that?
Yes, I think we're trying. I think something that we, holding events like this obviously is one way to do that. I think what we're really trying to do is encourage journalists to write about their own SLAPPs, but also the cases being brought against others, because that's the best way to really kind of reach a more mainstream audience. And there are, publications and outlets like Franz's, Open Democracy and others that have taken a real interest. The Guardian has been writing about cases a lot. And there's been concerns about doing that because then there's like a secondary sort of libel risk. A lot of the publications that try to write about other cases then potentially get threatened themselves. But just kind of the fact that someone's being sued or being threatened with being sued is a fact. And we should be able to talk about that. So yeah, I think more and more, hopefully, it will be coming to public awareness.
Thank you. What time? Got 1 minute. So if anyone's got a 1 minute sort of question, I will take it. If not, I'm gonna close the. So I just want to say, well, there's lots of stuff that's been here. So if you are being slapped, tell the SRA about it and support any case you hear about journalists being slapped, share it. The question about that Margarita raised is that if you know about it, talk about it to others. It's something we need to get out there, that it's something that can be fought against. We're going to hopefully keep pushing the MOJ. Eventually, they'll come out with what their position will be on reform. We will hopefully publish what we think the reform should look like. So check out FPC and Index on Censorship and the UK Anti-SLAPP Coalition. We'll be around for a little while afterwards. Also, Sunday is the anniversary of Daphne's murder. So please take a moment, read anything you can find of her, read her byline, think about her, because she was a remarkable woman, and writing remarkable things has really sparked this campaign for justice and accountability. And also, can you just join me in saying thank you to our amazing panel, both in here and on the screen? Thank you to all of you guys for attending, and for all of the digital people, and also for Yuka, who is up there. Wave, Yuka, for the amazing space. There is a really amazing exhibition downstairs, which is our work responding to Daphne's career and legacy. That's really awesome. I don't know what time this place closes, but thank you all for coming, and have a good night. Thank you.